Hello, my name is Michael Rodriguez, and I would like to talk to you about my honors project, Above the Law, a story of radium and special wastes in the legal system. My interest in the project came from many years of being a water well driller in South Florida. As a result, I was very interested in injection wells and the legality of injection wells. Therefore, when I was given the opportunity to choose a topic for research in my environmental law, policy, and management course, I chose injection wells. I had no idea at the time that I was going to discover radium in the oil and gas waste streams or several other wastes that weren't being properly or efficiently managed. What I found in that research and in this subsequent research is that six major industries have their wastes exempted from hazardous designation, even though many studies prove that the waste has hazardous characteristics. Even the EPA has identified the hazardous characteristics. A hazardous determination by a regulatory body such as the Environmental Protection Agency carries two different impacts. The first is increased protection of the environment and the public due to the proper disposal of hazardous wastes, and the second is the increased cost to industry from having to abide by more stringent regulations tied to hazardous waste. As the data regarding special waste spans several decades, I arranged it in the form of a timeline. For this presentation, I have color-coded the laws and acts that threaten hazardous determination in blue, and I have coded the studies and reports that confirm hazardous characteristics in red. Significant events in this timeline include the passage of the Federal Water Pollution Control Act in 1948 that set up sewage treatment plants and mentions the Oil Pollution Act of 1924. In 1965, there was the Solid Waste Disposal Act that was created or signed into law because of too much industrial waste. In 1970, the National Environmental Policy Act was signed, which created the EPA. The EPA consolidated all of the pollution functions from many different regulatory bodies. In 1972, the Clean Water Act was signed, and it had language targeting offshore oil facilities. In 1976, there was an amendment to the Solid Waste Disposal Act called the Resource Conservation and Recovery Act, which had stringent requirements for hazardous materials in a section called Subtitle C, and had language which directly targeted the oil and gas industry for increased regulation under Subtitle C. In 1980, the Bentsen and Bevill Amendments were passed. These two amendments gave exemptions to 6 major industrial wastes from being regulated under hazardous material classification. In 1988, the Environmental Defense Fund sued the EPA for not listing the wastes as hazardous. However, the suit did not result in a hazardous determination by the EPA. In 2010, the EPA proposed listing coal ash as hazardous after a 2008 spill. However, that rule was never finalized, and coal ash is still listed as just solid waste, not hazardous. Those were examples of some of the laws, court cases, and incidents which failed to properly classify special wastes as hazardous material. In contrast to these laws and determination are many studies that confirm the hazardous characteristics of these special wastes. For example, in 1978, the Denver Research Institute confirmed the link between oil and uranium in oil deposits. In 1988, the EPA's own analysis stated that up to 70% of the excluded wastes under Bentsen and Bevill could have hazardous characteristics. In that analysis, the EPA cites economic impact as one of the main reasons for not listing the waste as hazardous. In 1993, a report was published in the Journal of Petroleum Technology, which detailed the radiation in the petroleum industry. In 2011, the United States Geological Service did a study in Pennsylvania and found radium in the water from gas wells that exceeded the threshold for reporting by the Nuclear Regulatory Commission. In 2021, A study out of Yemen showed radium in all components of the oil production process. And in 2021, radium was measured in the discharges from offshore oil facilities in the North Sea. To better understand this data, I have arranged it in a graph of hazardous determination over time. I set 2 as the arbitrary limit for hazardous determination. Anything below 2 has not been determined to be hazardous, and anything above 2 has definitely been determined to be hazardous. When comparing the scientific knowledge versus the regulations, there is a clear disconnect between the laws and regulations that are in blue dots and the scientific studies and reports that are in red dots. That space in between the data represents the legal loophole in which several industries operate. An abundance of evidence demonstrates hazardous characteristics among the exempted wastes under the Bentsen and Bevill Amendments. To protect the environment, the public, and future generations, the Bentsen and Bevill Amendments need to be repealed. And the exempted wastes need to be classified as hazardous and radioactive. To read more about this and other pollution stories, please visit medium.com/ScorpiusMaximus.0. Finally, let us play a little game. Please pause the video and see if you can guess which one of these sources belongs to which one of the descriptions. To put these results in context, the Nuclear Regulatory Commission begins regulating radium when it exceeds concentrations of 335 picocuries per liter, and the outlier of 18,000 picocuries per liter was found in a natural gas well in Pennsylvania by the United States Geological Service.